All right, here we go. First thing we're going to talk about, and you notice at the bottom right, I'll have remember that just comes straight off of what I told you. Chapter 6, violation of licensing law, penalties, and procedures. And there's two questions that are coming from that chapter. That's Unit 6. Okay, so here's what we're going to talk about: administrative penalties. You got to know these. And so it's just a matter of resting your eyes on these and just getting to where you know what these administrative penalties are. These are issued, by the Florida Real Estate Commission. Remember, Florida Real Estate Commission is what's known as a quasi-legislative and a quasi-judicial organization because they're not the real legal system or the real legislation. They can't put a licensee in prison. They can only administer penalties and fines to them. Okay. And so you want to know these. Okay. So application denial, if they're going to deny an application, the applicant has 21 days to request a hearing. The letter of reprimand, if you see that on the state exam, that's the least severe. It's usually a first-time offense. It's just a letter of reprimand. Could be for, an advertising violation or something very minor that gets turned in as a complaint. Remember, anybody can file a complaint in writing, and you can actually go online with DBPR, and there's complaint forms that you can file. Anybody, licensee, non-licensee, anybody can file a complaint, but it's got to be in violation of the licensing law, okay, or 61J2. And so the least severe of all the penalties is called a letter of reprimand. And that kind of makes sense. Everybody kind of understands if anybody gets a letter of reprimand for something, it's usually a first-time offense. Don't do it again. Maximum 10-year suspension. Okay, that's the law. FREC can only suspend you or suspend the licensee for a maximum of 10 years. You got to know that number. Now, they can revoke a license, and that's permanently. There's also another term called revoke without prejudice, okay, or revocation without prejudice. And what that means is without prejudice means there was no complaint filed, there was nothing wrong that the licensee did, but the Florida Real Estate Commission issued a license that may have had wrong information on it. Could have been a wrong legal name, whatever information it has. So what they have to do is revoke it to reissue another license, okay? So it's without prejudice. There's no complaint, no penalties or anything like that. Your citation ranges is from 100 to 500, okay? Those are citations. Those are issued by DBPR and the DRE investigator. They range from 100 to 500. And you have 30 days to pay the citation or file an objection to the violation, okay? So if a citation is issued by DBPR for whatever cause, you got 30 days to pay the citation or object to it. And the range they can carry that citation is $100 to $500, okay? And then the Florida Real Estate Commission can, for more serious violations, can impose fines up to $5,000 per violation, okay? Per violation. So there's two charges. It could be 10,000, 3, 15, and so on, okay? They can impose probation, the Florida Real Estate Commission, which means they can make a licensee attend monthly meetings. And then DBPR for a first minor violation, 15 days to correct the action is an issue notice of noncompliance, okay? An issue notice of noncompliance, okay, is not a letter of reprimand. An issue notice of noncompliance, is that what it means? Noncompliance. Someone could have ran a marketing ad for some reason, and wasn't in compliance with the proper disclosures, for example. So DBPR can issue a notice of noncompliance, which is basically a 15 days. You have to correct that action, okay? 15 days. So you want to pay attention to these administrative penalties. You may see a few of them on the state exam. But the ones we're concentrating on are the citations, the suspension, 10 years, revoke, citations, 100, 300, 30 days to correct the citation. The fines are $5,000 per violation, okay? All right. The question may read, a sales associate was issued a citation. How many days does a licensee have to either pay the citation or file an objection to the alleged violation? Okay? Excellent. Remember, the citation range, 100 to 500. and the licensee has 30 days to correct the violation. Okay, 30 days to pay the citation, in other words. All right, so we're talking about answer C. Answer C. Very good. All right. Probable cause panel, or you may see on the state exam PCB panel. Let's talk about this for a second. What is the probable cause panel? So the probable cause panel is a two-member organization. It's comprised of two members, and it's kind of an intermediate stop, or what you might call a safety net to the DBPR, DRE investigation. Instead of them, it's kind of a balance of powers, if you want to sort of speak, right? You're familiar with the civil, the civil government. You've been through civics, and you see our government has a balance of powers with Congress and the Senate and the presidential and the Supreme Court. So you got a balance of powers. Same thing with the complaint system. Think of this, because remember, when the complaint is filed, listen to me carefully. Complaints filed, DBPR and DRE are going to begin this investigation. Remember, DBPR is the big conglomerate. It's the big conglomerate over all the industries in Florida requiring licensing. DRE is the division of real estate under DBPR. They assist the Florida Real Estate Commission. Okay. So during this investigation, they've got the complaint first, and they're going to file the actual complaint, or they're going to file the not file, but they're going to investigate the filed complaint. Okay. Now, this is where the actual DBPR secretary, which is a high position, okay, very high position, the DBPR secretary can file a summary suspension if it's so egregious, the act that the licensee committed, that they're going to put that license into a suspended role until the outcome. Okay. And it's got to be real egregious. Okay. Under normal complaints, if it's not an egregious act, the licensee can stay active and stay licensed, because this process can take a long time. And so only if it's an egregious act can the DBPR secretary make a decision to apply a summary suspension at the very beginning until the outcome. Okay, which means they can't do any real estate business. Okay. Now, what would be egregious? Well, that's up to them to determine, but I guess the closest example is if an agent took a $5,000 deposit check, right? Client went under contract on a condominium they bought, gave the agent a $5,000 deposit check, and the agent went and deposited in their personal account and went on vacation. Okay. And said, when I get back, I'm going to get my income tax check. I'll redeposit it with the broker. Big violation, obviously egregious. In that case, the summary suspension would come from the DBPR secretary, and that licensee would be suspended until the outcome of the investigation. Okay. Now, that's the first big picture step. DBPR, DRE, going to investigate. If they see a need to further step this into investigation, they forward the investigation to the PCB panel. Okay. Here's your balance of powers now. So now the PCB panel is going to take from DBPR, right? They're going to take from DBPR the actual investigation and the need to investigate it further. Okay. Now, when you talk about the probable cause panel, it's made of two members. You got to know this for the state exam. One of the two panel members has to be an active licensed professional. Okay. Has to be an active licensed professional. Okay. Now, one member has to be a current member of FREC, which is the Florida Real Estate Commission, right? The other member can be a current member of FREC, but also can be a former commission member. Now, if they're a former commission member, they have to be active if they're called back to operate under the PCB panel. And if you think about it, we've got seven members. All the complaints that go on in Florida, that would tie up a lot of the commission members if they had to operate under PCB panel. And so what they can do is the state allows, the revised statute, or the 475 allows for active former commission members to come back in and operate only under the PCB panel, but they have to be active, okay, in order to sit that role. So DBPR forwards it to the PCB panel, 2 members. One member's got to be a current FREC member. The other member can be a former member, but they must be active, okay? So the question may read, which statement is false regarding the probable cause panel? Before you go into this, let me explain to you how I do true false. So you can review again under your breath about the probable cause panel, what it consists of, what the role of it is, etc., which is nice because that'll help you look for an answer. But when you're dealing with true false, I actually take each answer and turn it into a question. And here I'm looking for 1 false statement and 3 true statements. So I've got that set up beforehand before I start reading each answer as a question. I'm looking for 1 false and 3 true. So which statement is false regarding the probable cause panel? Okay, good. We got a few mixed answers here. We got a lot of people coming in with some mixed answers, which is what this is what we're here for. Now, listen to me carefully. If you go through and turn each question into each answer into a question, it's going to take you a little bit longer to answer. Okay, so I had some answers go up pretty quick. So try to start practicing a little bit of continuity in your answer selection. Okay, so again, which statement is false regarding the probable cause panel? I'm going to kind of go through my head mentally of what the probable cause panel is. And then my last thing I'm going to do, I'm going to say, look, I'm looking for 1 false and 3 true answers. So my first answer is, I'm going to make this a question. A consumer member may serve on the probable cause panel. And the answer is true. Remember, any current commission member, out of the 2, 1 of them has to be an active licensee though. But a current consumer member, as long as they're an active commission member, can serve on the PCB panel, okay? Number 2, B, at least 1 member must be a professional member. That's what we're talking about. Absolutely. That's true. The Florida Real Estate Commission chairperson appoints the probable cause panel. That's true as well. And the last one says a former commission with an inactive real estate license may serve on the panel. And we know from our studies, if we're going to use a former member, what do they have to be? They have to be active. So that's a false statement. They cannot serve on the panel as an inactive real estate licensee. If they're active, the former commissioner can serve as a PCB panel member. Okay. So we're talking about answer D. Okay. Again, when you go through these, set them up as individual questions and answer each question true or false. And this is where you have to know about the PCB panel. Okay. And we know in our studies that a former commission member has to be active in order to serve. Okay. So we're talking about answer D. All right. Let's talk about the recovery fund. This comes out of chapter 6. 2 questions. This is a big topic here. Remember, the real estate recovery fund is kind of a safety net for licensees. Okay. In the event they get sued, they got to be, first of all, it's got to be a complaint, from the civil side of things. It's got to be a violation of 475. It's got to be a violation of 61J2. And basically what happens is the consumer's been injured in a transaction, okay? Suffered monetary losses, okay? And so they file a complaint, and then the licensee has to try to attempt to pay for it himself or herself, okay, out of their own personal funds. If they can't, and they can't have, and of course their E&O insurance would kick in, which is what you're going to be applying for when you get errors of omission. You'll be applying for that insurance. But personal funds and E&O insurance, if that doesn't cover the actual monetized suffering of what you're being sued for, um, or actually what your client is suing you for, then you can go into the recovery fund for the remaining portion. Okay. The licensee, here's what you want to know, is suspended until the recovery fund is repaid. Okay. So you are suspended. The licensee is suspended until that's repaid. Okay. Now, the payments from the actual recovery fund is $50,000 per claim. Okay. And depends on the number of claimants. The total payment cannot exceed an aggregate of $150,000. Okay. The licensee has to be active at the time the act was committed. Okay. The licensee cannot be acting as a principal owner. In other words, they're not selling their home, or they're not acting as a purchaser or a principal. Okay. They don't get any um, uh, access to the recovery fund. If they're own the property, and they got to be licensed, they got to be active, and they can't. The licensee cannot represent a spouse in a transaction and expect to use the recovery fund too as well. Okay. So the big things about the payments from the recovery fund: $50,000 per claim, regardless of the number of claimants. If there's 4 people suing, there's 1 claim, then it's going to be that number divided by 4. Each of them get that much. So not each of them get 50,000. Okay. And then the total cannot exceed 150,000. All right. The maximum payment from the real estate recovery fund for a judgment issued in connection with a single real estate transaction is what? Yeah, this is kind of a little bit of a test question that's not really clear. Remember, it's 50,000 per claim regardless. Okay. So I guess the terminology you're looking for is the word claim versus aggregate. Okay. So the maximum payment from the recovery fund for a judgment. 1. Remember, these key words you're looking for are very important that you read this, because it can be confusing. You can see they have a couple of correct answers. 50,000 and 150 is what we're looking for. But it's the wording that's going to be the difference in this. And so we see the maximum payment from the recovery for a judgment, which means one judgment. Okay. One judgment is going to be 50,000. Okay. Again, regardless of how many people are making the claim per transaction. And so a judgment, it represents per transaction. So you got to be careful. This is one of the testmanships that I'm trying to teach you on these test question analysis. You got to slow down a little bit, and you got to analyze it. This is why I like to read the question 2 times. Okay. And then I go back and look for keywords. Maximum payment. Okay. So I know the maximum payment per transaction is 50,000. I'm reviewing this in aggregate, which means total I can use from the recovery fund is only 150,000. So there may be another lawsuit down the road. So that adds up to be 150 is my total aggregate. But the maximum payment per transaction. So knowing that, I'm looking for keywords again. The maximum payment from a real estate recovery fund for a judgment. So I'm thinking a judgment is 1 payment, 1 transaction. So my best selection would be answer C, 50,000. Okay. Very important that you do this. Develop a system. I'm telling you, it's going to work for you. You got 3.5 hours to take 100 questions. Develop a system where you're reading these questions twice. Look for keywords. Okay. Look for keywords and know that they're going to have, if you see 2 answers you recognize, like 50 and 150,000, you better go back and make sure the wording's right, because there's two of the correct answers are there, but only one of them is the correct answer. Does that make sense? Everybody good? All right. Let's circle back. We talked about administrative penalties. Let's look at a little bit more in depth when it comes to criminal penalties and licensing reporting. Okay. Now, this is not as an applicant. Okay, remember, as an applicant, you got to report everything. It doesn't matter when and where it took. If it was in high school, you got to report it. But now you're licensed. Okay, so now the reporting as a licensee to the Florida Real Estate Commission has to be within 30 days if it's a plea guilty or nolo contendo, misdemeanor, or felony, regardless of where it took place. Remember, what we talked about before is applicant. Okay, is applicant. Here we're talking about a licensee. If a licensee is, commits a misdemeanor or a felony crime, they've got 30 days to report to the Real Estate Commission. That's within 30 days. Now, the criminal penalties, second-degree misdemeanor, that's false advertising. That's going to be $500 or 60 days in jail. You want to know that. Second degree is false advertising. First degree is failing to provide an accurate or current rental list. Okay, that's $1,000 or 1 year in prison. And then a third degree felony is going to be $5,000 or up to 5 years in prison. Okay, $5,000 or 5 years in prison, and that's unlicensed activity. That's the big one. If you're getting paid a commission without having a license, you could fall under a third degree felony. Okay. All right. Which statement is true regarding a real estate associate, sales associate, who is convicted of a DUI or driving under the influence? Good. Excellent. So we're talking about answer A. The sales associate must report the DUI conviction within 30 days to the commission. All right, let's talk about ethical practices. I'm going to start on C. I'm going to start on C with misrepresentation. And D. I want to talk about C and D first. Okay, pay attention, be carefully now, because this is really, there's about 2 or 3 questions that can come from this section here. Misrepresentation and fraud are 2 terms you want to know when it comes to ethical practices. Misrepresentation simply means what it is titled. You've misrepresented. It could be, and in most cases, the misrepresentation is, what's the word I'm looking for? It's not intentional, unintentional. Let me give you an example. If I'm taking a listing, in other words, I went out to a listing, signed the agreement, everything's good to go. I'm measuring the house and I calculate heated and cooled space, 3,500 square feet. A total 4,200 square feet. Okay. So total or gross is 4,200. Heated and cooled living is 3,500. I input that in the MLS. Buyer submits an offer. My seller accepts it. We're on the contract. It gets appraised. The appraiser comes back in the appraisal report and says the house is 3,200 square feet. Living. HVAC. 3,200 versus my 3,500 input. So we're 300 square foot off. That's a gross error. Very gross. Okay. So what happens there? Well, there's misrepresentation. It could lead to legal issues. Okay. It will definitely lead and can lead to what's called a voidable contract. So we could be, 6, 7 days out from closing. Everything else is complete. All the contingencies are exceeded. If I got out of the contract, or if the buyer got out of the contract, I could sue the buyer for specific performance or for liquidated damages. But in this case, because the appraisal came back 300 feet short, that buyer has been injured in this transaction and has by law and can be voidable in the contract and leave and get their deposit back. Okay. All because of misrepresentation, false or misleading statement. And again, unintentional. It wasn't intentional, but it could lead to serious damages. Because of that mistake, my seller may be upset with me because they got to be in another state starting a job in 2 weeks. And now they've lost this contract. So you can see how this can snowball. So misrepresentation is a very serious term when it comes to ethical practices. Now, misrepresentation, if it's done intentionally, becomes fraud. Let's say I measured the home and I came up with 3,200 square feet. And all of a sudden, I'm saying to myself, well, I'm going to put 3,500 in the MLS, but I know it's 3,200. Nobody will know, right? That's fraud. Okay, so misrepresentation is more unintentional. Okay, could lead to legal issues like we were talking about, but fraud is intentional. Okay, damages must occur to have fraud be a charge of fraud be brought on somebody. Okay, so misrepresentation and fraud kind of hitch together. Okay, now when it comes to culpable negligence, that's just a neglect of your duties towards your client. Okay, it could be from an act of misrepresentation. The culpable negligence is just a neglect. You're just not taking care of your clients. Okay. And then, of course, disclosure. You got to have the proper disclosures when it comes to the property, as far as the seller to the buyer, etc. Okay. Now, let's look at trick, scheme, or device. Remember, in the state of Florida, you have to have an auction license and a real estate license to auction off property. And those are the people that talk fast. You know, you've seen the auctions. They talk real fast and people bid on the properties at an auction. Got to be an auctioneer. So you're licensed as an auctioneer, and you have a real estate license to auction off real estate. No one cannot sell lottery tickets. That's a form of auction. Okay. So no one can sell lottery tickets to the public for $100 a piece until they get the required money that pays the house off, where someone gets drawn from a container and they get a house transferred to them for $100. Okay. That's called trick, scheme, or device. Okay. So brokers cannot sell lottery tickets. The only time property can be in any fashion is auctioned with a proper auctioneer's license and a real estate license. Okay. So you may see a question like this: a property owner and a broker decide to sell $20 lottery tickets to prospective customers for a chance to win the property. They announce that if 1,000 tickets are sold, the winning ticket will get the property free and clear. If less than 1,000 tickets are sold, the winning ticket will get the property for a price of $200 minus the value of the ticket. Which statement is true? Good. Charged with fraudulent and dishonest dealings by trick, scheme, or device. Okay, very good. Can't do that. You can auction off, but you got certain requirements to be an auctioneer, and that's again to have an auction license and a real estate license. Okay, this is illegal. Very good. All right. Administrative penalties. Again, a nice review of this. A revocation of a license means it's permanently revoked. Revoke without prejudice. You may see this on the test now. This is where a license may be issued by mistake. They have to revoke it to reissue a new one, but there is no administrative penalty for it, okay, because there was no complaint. Remember, the applicant has 21 days to be heard why they didn't get their application accepted. We know about letter, reprimand, suspension, maximum of 10 years. Citations are 100 to 500, 30 days to pay them. 5,000 per violation on fines. Okay. And then notice of noncompliance, again, a first response to a minor violation, 15 days to correct the action. All right, an applicant was issued a sales associate license by mistake. She has been informed that the license has been revoked. Which applies? Very good. Excellent. Revoke without prejudice. Very good.
For more practice questions, videos, and insight into the state exam, we encourage you to join our free webinar, How to Pass the Real Estate Exam Without Your Real Estate Book and with only 15 to 20 hours of study time. Get registered now at myrealestatetutor.com/exam.